comments. I'm going to record. If you can please accept it on your side. If you do have background noise on your side, please do mute yourself. Otherwise, we're going to have to do that. Kyle, if you can just help me keep an eye on the waiting room, that will be appreciated. And as I said, ladies and gents, good morning and welcome to our October, I almost said November, October webinar. We are very honored to be sharing the spotlight this morning with Hendrik Hoffmann of Rise Property Solutions. Hendrik, for those of you that don't know, also founded the very popular Facebook group called Sectional Title Living in South Africa. So we're very, very pleased to have him join us this morning, and we're talking about quite a hot topic. I know that it's a topic that makes us as consultants quite hot under the collar. So we're going to be looking forward to sharing information on this topic this morning. Nicole Nell is going to do a little bit of an introduction for us. And for those of you that don't know, Nicole has recently submitted her master's thesis on the very topic that we're going to be talking about today, but I'll let her tell you a little bit more about it. Nicole, over to you. And if you can just share your spotlight with Kyle, and he can give us some information about future events, and then we'll hand over to Hendrik.
Perfect. All right, so I think Kyle, maybe go first, and then I'll introduce Hendrik, and then we can get started, and I'll give some information to everybody at the end.
Okay, perfect. Right, good morning, everyone. I hope everyone is doing well, and thank you so much for tuning in to our webinar this morning. As Elena said, this webinar is going to be recorded, and it's going to be published on our YouTube and social media platforms. So please make sure to subscribe to our channel and like the video. It really helps a lot. And then if you haven't already, please do sign up to our newsletter. This way you can keep in touch with the TVDM consultants team. In the latest TVDM Table Talks discussion will be happening tomorrow at 11 a.m. This is a segment where once a month you will have the opportunity to ask our consultants any community schemes related questions you may have live on our neighborhood. This feature is only available to paid for members though. We will be releasing the link to join on our neighborhood tomorrow morning, so make sure you don't miss out. And then if you're looking for training, make sure to check out Charterfin's trustee training in conjunction with TVDM consultants. I'll post all these links in the chat. Right, thanks. Over to you, Nicole.
Awesome. So as Linda just touched on, our topic for today's webinar is on our lovely regulator of community schemes, the CSOS, Community Schemes Ombud Service. And for those of you who don't know, it is their 7-year anniversary this year. Actually just passed now on the 7th of October, last week, Friday. And I'm sure most people in this webinar have had some or other experience with CSOS since their 7 years of establishment. And I'm sure some of you, if not all, have had some kind of inconvenience or misstep or something go wrong throughout your CSOS experience. This is what we're going to be talking about today. And with us, we've got one of our fantastic colleagues, Hendrik Hoffmann, who has ample experience with the CSOS and likes to challenge them almost as much as I think we do. So we could think of no one better to go forth on this topic with us and explore it. So let me just give you a little bit more information about Hendrik. So upon completion of his BCom degree in business management at Tuks, University of Pretoria, Hendrik embarked on a career in sectional title, and with more than 10 years of experience under his belt, he recognized a pressing need for enhanced transparency, streamlined processes, and superior service through the incorporation of technology. This prompted him to establish Rise Property Solutions in 2018. Hendrik's extensive knowledge and proficiency in sectional title matters have earned him invitations to numerous radio shows where he has served as a valuable guest speaker, just like on this webinar. He has also established the largest Facebook group in South Africa dedicated to sectional title living, further cementing his reputation as a leading managing agent in this industry. And we're so looking forward to what he has to say. Over to you, Hendrik.
Awesome. Thank you. Good morning, everyone. The worst part of the webinar is always that bio bit. It's I must tell you, I wanted to buy a cupcake for CSOS, and then I thought I'm not going to waste my 10 Rand. But I don't want to I've been very nervous about this chat because I don't want to sound all negative. And, you know, in the beginning, there's been negativity around CSOS for quite a while, and I really tried my best to stay positive and see the light at the end of the tunnel. But I must be honest, this past year, and after certain, you know, cases that I were involved with, I really started losing hope a bit. So, yeah.
That's a nice way of saying it, unfortunately. I think it's a situation that a lot of us have had as well. I posted quite a long post about a year or so ago where I was going to start the year off with vigor and renewed faith and confidence and all those fun things, but very quickly it got dashed. I think we had a very, very, very good chief ombud the last round around, and he made an excessive amount of progress. There most certainly has been quite a bit of improvements. But sometimes things feel like it's going all downhill again. Yeah, so yeah, not a great situation to be in. Nicole bumps her head very, very often. They've actually recently you know, expressed a little bit of news that Nicole's going to share as well, about some recent developments. So yeah, interesting times ahead, most certainly. Sorry, Hendrik, for interrupting.
No, that's fine. It's you know, in the beginning, I think the adjudications and the mediations, it worked, it was successful. Yes, there were teething problems, but you know, they were moving in a certain direction. And this last year, the wheels have just been falling off the bus, and the adjudications have just been ridiculous. And it's been a waste of time quite often. I mean, recently, I brought a CSOS case. The body corporate fired the managing agent. They're not handing over the documents. We brought a CSOS case, and CSOS said they don't have jurisdiction. The explanation was that the contract has already been terminated, and it's not one of the prayers or one of the reliefs in terms of their act.
I've got some, thank you. And so have you.
I asked them about, you know, the PMR that says it must be handed over within 10 days and whether they think they don't have jurisdiction over that. And they just said, no, they don't. Then I said, okay, but here's a case I did 2 years ago, exactly the same. I got an order against the previous managing agent to say they must hand over the files. And the response I got from CSOS was, yes, they can see that order, but the adjudicator shouldn't have made that order. Which is strange, you know, and
that
other.
Is strange, Hendrik, that is strange because then on the flip side, I've had experiences where I've lost, or my clients have lost the CSOS order because the other side have relied on past CSOS adjudications where an incorrect order was handed down, and then the adjudicator relied on that. So I think that highlights the inconsistency in the process for sure.
I mean, talking about inconsistencies, on one of the body corporates, they changed their rules at the AGM. It was registered, everything was fine. At the next AGM, they wanted to change the parking rules, and it was approved and it was submitted. And CSOS came back and wanted changes on some of the previous rules they had approved before. But I think where my gripe started was and I was disappointed with that, was in a case where I manage a mixed title body corporate. So it's shopping center at the bottom, office block, and then flats on the other side. And the shopping center and the office block belongs to the same owner. They then went and changed the office block to student accommodation, which is change of use, and you need a unanimous resolution. We brought the application, they responded through an attorney, and I mean, you know, attorneys, it was all these points in limine and trying to get the thing thrown out on technicalities and blah, blah, blah. And I objected to the attorney being present. I said, I'm not going to answer all the points in limine because it doesn't relate to the dispute. We just want to get the dispute resolved. And I answered on those items. And the next moment we got an adjudication order. You know, they didn't come back and say, no, they will allow the attorney, or, you know, they not allow him or whatever. We got an adjudication order, and the case was dismissed with for two reasons. The first one, the points in limine, which was completely irrelevant. And the second one was they ruled that the city of Tshwane has approved the student accommodation, and therefore it is legal. They didn't even touch on the Sectional Title Schemes Management Act. So needless to say, I was very upset, contacted CSOS, and I said to them, do you remember about 4 years ago, we brought a case against a cousin of a minister, and it wasn't even part of the case, but she wasn't paying her levies, we've attached furniture, and you phoned me and you said to me, we know we don't have the right to ask this, but can you just hold on with the auction until after this case? And I said, sure, no problem. I'll help you guys. And then 2 years ago, there was a very high employee of the Gauteng government who brought a CSOS case against me. He didn't attend the mediation, case was closed. 5 days later, he brought the same case. I said to them, sorry, case has been closed. And they called me and they said, look, we know the case has been closed, but would you mind opening it? It's in the interest of justice. And I told them, well, look at this order. I mean, this is ridiculous. So I'm asking you to now return the favor. Please, can we have this opened and looked at again? And the response I got was, you know, we looked at it. You have very good grounds for an appeal. You'll need to go to court. We can't help you. So now a body corporate needs to go to court, spend tens of thousands on an appeal. You can't get a cost order against anyone. And they actually admitted that it was just a ridiculous order. And that's kind of where my hope for CSOS really just disappeared. And ever since then, that was a year ago, ever since then, it's really become ridiculous. When was it? About a month ago, we got an application from an owner asking that we should stop legal action against him for arrear levies, and we have to accept his proposed payment arrangement. Went back to CSOS, I said, guys, you don't have jurisdiction. They said, yes, no, that is quite correct. They were just wondering whether we will deal with, whether we would be open to the payment arrangement, and we, took it from there. 5 days later, I got another application, and I couldn't open the attachment. I asked them, please, guys, just send in a different format. I can't open it. Didn't hear from them. I went on leave. I came back. 3 days later, we got notice that it was referred to adjudication. Threw my toys again, and they scanned it in and sent it to me in a different format. And it was exactly the same application as the previous one. And I said to them, but guys, we've already dealt with this, number one. And number two, you don't have jurisdiction. You know that. Why are you going to adjudication? Why are you wasting my time? Why are you wasting your resources? What is happening here? And that is basically what we're dealing with now. And sorry, one more. Just last week, in a building that's busy installing water meters, shafts are inside the flats, and so, they need to break open inside the flat. We got an application from an owner saying he's got a hole in his flat and the body corporate should close it. We responded by saying, yes, we are aware the project isn't finished yet. They still need to work there. Yesterday, I got a notice it's going to mediation. Why? Why should I go sit in a mediation for something that we've answered? And I think that is one of my big frustrations. I think CSOS doesn't realize, in most circumstances, the managing agent would represent the body corporate, and managing agents are very busy. And it really feels like they're just wasting our time. And I don't know why.
Yeah, so many points to touch on. So I think firstly, I think the first thing to discuss is, your whole discussion on natural justice and how CSOS seems so adamant about it and things like that. However, I would like to just put on the table, how is it natural justice when an applicant in a CSOS dispute resolution, which either is a body corporate or an individual owner or any person really, any normal person, who's trying to get relief from the regulator of community schemes that was established for this very reason, how is it in the natural course instance of justice to just dismiss the application or give an incorrect order, and then when it's questioned, it's like, oh, just go to high court? Like, I'm so sorry, but what was the point of this entire laborious process just for someone who most of the time, unfortunately, that does not seem to understand how sectional title schemes work or how the STSMA operates, and now it becomes your problem? I don't think that it's fair, especially in the whole argument that CSOS was set up as an institution for justice for people in community schemes, so that they don't have to go to the expensive cost of court. That was the whole reason that private arbitration was removed from the Sectional Titles Act, was because, yes, even though it was cheaper than court, it's still really expensive for the average South African living in a community scheme that pays a bond, pays levies, pays rates, you know? So that's the first thing I would like to touch on. But then following on to that point, we very recently, yesterday and this morning, basically received very upsetting news. And for those of you who subscribe to the CSOS and are on their newsletters and things like that, I think it was in February or March of this year that they circulated the draft practice directive, where, you know, they were saying, are we going to widen the scope of section 39(7)(b) of the CSOS Act, which is essentially any other order that the chief ombudsman proposes as reasonable, or something along those lines. And they were adding all of these amazing things, like, oh, you can actually, they have a say in contracts, they have more power over managing agents, things like that. But the most wonderful proposition for me, or proposal, was the potential introduction of an internal review process for adjudication orders, so that you could take an adjudication, if you were the dissatisfied party, you could then take it on review within the CSOS, and then they would consider it based on the merits and things like that, thus, you know, taking out the point of having to go to high court. Because I think something people need to remember is that sectional title in South Africa and dispute resolution is very much based on, you know, the jurisdictions of Australia and Singapore, which are fully developed first world countries, where bureaucracy and government is operating at an extremely efficient level. And then when they try to incorporate it into our country system, unfortunately, I think a lot of us forget that CSOS is government. It just doesn't translate well. And then the last point I want to touch on is your whole point of forced conciliation. Something I discuss in my dissertation and my thesis is the fact that, personally, I've never been involved in a conciliation that's been successful. I've always been involved in matters that have been referred to adjudication. And furthering on to that point, I think the reason that conciliation is so unsuccessful at the CSOS, in my opinion, of course, is because CSOS is the party that decides whether it's going to go to conciliation. I don't think that they understand that once at the point that the dispute reaches the, you know, CSOS dispute resolution process, in my opinion, the relationship has broken down so much between the parties. There's honestly not much hope of resolution by sitting around the table. And furthering on to that point, I do feel that in a lot of instances, conciliators really struggle to actually facilitate resolution when there is so much animosity between the parties already. And I actually have seen how conciliation further frustrates the dispute resolution process, because it can get so nasty and acrimonious between the parties. So yeah, those are just some things that I wanted to mention.
No, definitely. So in preparation for today, I was trying to think what went wrong, what is going on, and I think there's two things that CSOS needs to do if they really want to get anywhere. I think the first thing is that they have various mandates that they need to perform. So they've got the basic stuff, you know, the rules, the dispute resolution, etc. Then they've got the more high level, let's call it idealistic things that they need to do, which is, you know, development funds and transformation and all those.
And educate the industry, all of those things.
That's it. Now, all of these things are very noble and very necessary, I agree. But if I look at basic business principles, myself as a business owner, I've got different goals, and I've got my high level goals and I've got my basic goals. If as a managing agent, I have the best software on earth and I do 1 million webinars and I market myself as being absolutely amazing, but I can't do basic financial statements or month after month send out levy statements without mistakes, my business won't grow. And I don't think CSOS has the luxury to concentrate on the ideological goals yet. They first need to get the basics right. It's taken 7 years and it's not right, and it's becoming worse, and it's because their focus has shifted. Get that right, and they will get much more buy-in on the other stuff that they need to do. But I think you mentioned that we should remember CSOS as a government institution. I think that's why they're concentrating there. It's politics, really. So that's the first thing. The second thing that I really wish CSOS can realize is that their biggest stakeholder is the managing agents. They've never communicated with us. They've never given us training. They've never had sessions with us. When Jolene was there, it felt like we still had a bit of an ally. Ever since she's left, I don't know who replaced her. And I'm sad to say that the last couple of months, it felt like they see me as the enemy. As if they go out of their way to frustrate me. I mean, can you imagine if we can just take hands, the impact it will have on this industry? But I don't think that's what they're interested in. I think they're interested in scoring politically or whatever it is that they need to do. And I think those are the two things where they're going wrong.
Absolutely. And so I haven't been in the industry as long as a lot of people on this call have been. So when I started and Zelinda introduced the concept of CSOS to me, I was like, oh my gosh, this is amazing. Oh, it's okay. They've got a little bit of hiccups. It's fine, guys. It's fine. It's fine. It's not fine. After 2 years of being with it and being in the trenches, I would like to say, it hasn't been fine, because it's almost like every single day when I engage with an employee from CSOS, I feel like I'm speaking to a different organization every time. No one has the same opinion. No one gives you the same answer. When something urgently needs to be done, I feel like they just forward emails around to different people. There's times when Zelinda and I and Matthew have, requested urgent feedback on matters, and they come to us and it's 3 weeks later. And our clients, our bodies corporate, our trustees, they get so frustrated with us, but I really want them to know that we are trying as best as we can. Like you said, you feel like CSOS sees you as the enemy at this point. I also, well, I don't feel like that exactly, but I just feel like they see an email from us at TVDM and they're like, oh no, not these goals again. And then they kind of just read it and file it, but I think it's because it's people like us that are unfortunately causing issues for them by calling them out on all of these mistakes that they're making. And unfortunately, the thing that I have found is that they just don't have answers for you. When there's been a massive mistake, no one has an answer for you. For example, Zelinda and I had a matter where, an owner wanted to change of use of their garden area to a parking area. And we reached out to the CSOS because it's a section 13.2 application in terms of the STSMA, if any owner unreasonably withholds their consent. And it was only one owner that was withholding their consent. We approached CSOS noting that there's no unique form for a section 13.2 application. And we liaised with CSOS and things like that, and they told us, oh no, it should be a section 6.9 application. And for those of you who know, that's an application that someone would make if they are trying to get a special or unanimous resolution passed. It's not the same as a change of use request. Anyways, after 2 years of fighting with the CSOS, they eventually came back to us to say, you need to make a section 13.2 application, which is what we approached them with 2 years ago.
So We've spent almost 30 minutes talking about the negatives and things like that. And I see someone has posted, you know, what are we going to do moving forward? And I think we can probably talk all day about all the negative things. And I see, Hendrik, you've obviously still got a lot more to say. Just at this, you know, juncture, I would like to say that, you know, this is not intended to be a CSOS bashing session. We're simply looking at a specific point in time. And I think 7 years on the 7th of October was quite a big thing. So we want to play on the whole 7-year issue. And for those of you that know the saying, the 7-year itch, you know, when it comes to 7 years, we have to make a decision. Are we going to accept the relationship as it is and stick with it? Or are we going to do something about it? And, you know, I'm incredibly proud of Nicole doing her master's and being the first South African student to do her master's on the CSOS. And I believe that from an academic perspective, that is most certainly going to carry some weight. From a practical perspective, other than really encouraging any applicant or respondent to approach people like us in the industry, people that are able to assist them, sectional title attorneys, sectional title consultants, managing agents, you name it, anybody that can assist in putting together a proper application, responding to an application, holding their hand through the CSOS process, knowing when to say, this is how it should be, that's not what it's supposed to be. That's the type of advice that we need, because once you get the order, it's too late. Once you get the order, don't come to us, don't complain to us. There's nothing we can do. We used to be able to go and borrow, beg and plead with the Community Scheme Ombud Service, with the Chief Ombuds, to try to have a look at the matter again. The CSOS are becoming very adamant that they're not going to look at a matter again. They want you to go to the High Court. They want you to take on an appeal. They want you to take it on review. And they're simply going to abide by that order. And you're going to be 50, 200, 250,000 Rand in the hole going that way. So make sure that you do the applications the right way. And for those of you that don't want to approach the CSOS, and that's going to be our biggest piece of advice, and we were mentioning it a little bit before the session as well, we are going to encourage you to mediate informally first. Go the route of informal mediation, go the route of internal dispute resolution. Talk to the person that you've got an issue with, talk to the managing agent, talk to the trustees. We consult with so many people that give us an issue or a problem. And when we say, did you speak to the other side? No, I haven't. No, I can't get hold of them. No, I haven't tried. No, it's going to be pointless. Speak to the other side. And if you can't do it on your own, then keep an eye out for later this year, beginning of next year, where we're going to start offering private mediation, where you can avoid going the CSOS route and try to resolve it using an external person, any one of the experts in the industry that is able to assist on a specified matter. And I think that is something that was mentioned in one of the chats, is that a lot of the adjudicators do not have the correct knowledge for a specific matter, a waterproofing matter, a levy collection issue, a barking dog issue, whatever it might be. So yes, there is a lot of problems to get through, and we can talk about it all day, but there is a solution at the end of it. And Nicole, I know you're going to chat about it a little bit more. Hendrik, sorry for interrupting you there. I just didn't want to doom and gloom the whole hour, but back to you.
Yeah.
No, that's fine. Look, and I'm glad you change it to a more positive tone, because the question really is, what are we going to do about it? And I think the simplest thing we can do, not simple, I don't know how on earth we're going to do it, but the easiest solution would be to persuade CSOS to involve the stakeholders, especially the managing agents, to let us give them advice, to let us sit together on how to do things. Let them give us some guidance, let's just all work together. If we can do that, it will go a long way to solving the issues we've got. If we can't manage that, then, the only thing that is really left for us to do is, I've been thinking at one stage, maybe we should get the buy-in from managing agents to kind of do a monthly contribution, and then we start taking all these things on appeal. Kind of force their hand to say, look, guys, it's becoming a problem now. That's the only other solution I could come up with. I know that NAMA is actively busy in doing good work and kind of liaising between everyone, but I don't think everybody necessarily subscribes to NAMA. I think they need to, each managing agent has different ideas. And I think, NAMA won't be representative of all the potential positives that can be added or the changes that's possible. So I think just better interaction is definitely the key to solving the concerns.
Definitely. Yeah.
Yes.
Sorry.
Don't be quiet now, guys. Continue your rant and rave, no problem.
I think
to reprimand you.
I think so obviously, as Linda mentioned, for my thesis, I actually focused on a critical analysis of the CSOS Act, particularly focusing on the dispute resolution clauses and how could it actually be improved in South Africa. And then, like I mentioned earlier, I compared it to jurisdictions in Australia and in Singapore, where we take inspiration for our sectional title legislation. And just some highlights, I would say, are some things that I obviously identified as big problems are, I would say, the fact that conciliation is forced, the fact that the praise of relief offered, even though there's 29, and that seems like a lot, it's actually not when you consider the variety and the complexity of disputes in community schemes, because something that I found in my experience is if your dispute does not fall perfectly within one of the prayers of relief that is offered by the CSOS, they'll often immediately say, oh, we don't have jurisdiction, or they don't deal with it correctly, or something like that. And then my biggest recommendation, I would say, is reintroducing the CSOS fees. When CSOS did away with the application fee and the adjudication fee, like Hendrik said earlier, it was extremely noble of them, as their whole argument, Z, you're on mute, as their whole argument was, we're expanding it even further, offering an even wider scope to people for dispute resolution. But the problem that I think has created is time and time again, CSOS has provided us with excuses, or we are short-staffed, or we don't have enough people in this department at the moment. Someone on the chat I see said, why is the GP CSOS office dealing with Western Cape disputes? And the reason that they've provided us is because they don't have enough staff. And the only logical reason, and please, disclaimer, I'm not a finance person, but I can assume that it's because they don't have enough of an income coming in. And I really believe, firstly, in comparison to the overseas jurisdictions, in Singapore, for example, it costs $550 just to make an application. To put that in perspective, that's 3,800 Rand. And that's only to make the application. It's like another $1,000 for it to go to adjudication. And then in Australia, it's 500 Rand to make an application, and then 1,500 Rand for it to go to adjudication, which, is reasonable, I would say, because it adds legitimacy to the legality of the process. And I believe with reinstating the low fees, it doesn't have to be exorbitant, but 50 and 100 Rand does not seem liable or practical. They could employ more staff, more people would be able to sift through evidence for dispute resolutions, more people would be available to actually conduct conciliations, conduct adjudications, manage cases, quality assure documents that come through, those kinds of things. But unfortunately, all of those things require an amendment of the Act. And I know Zelinda was in very close contact with the former DA Shadow Minister of Human Settlements, who said that government is looking, again, towards amending the SCSMA and amending the CSOS Act. But it's not on the Parliament's radar or list in the immediate future. So I don't believe that, yes, I believe that an amendment of the CSOS Act is the end goal and things like that, but statutory reform turns very slowly in South Africa. So what do we do now? And that's the other side of my thesis, where it's, instead of introducing, reform through statutes, it's CSOS actually just doing their job better, and, us as stakeholders really performing and doing our job correctly as well. So when making an application, it's short, concise, comprehensive, deals with all the facts. You show up to conciliation, you show up to adjudication, you do final written submissions, you do everything in your power to make it a successful process. And I know that when you are in the process, it seems laborious and you seem hopeless, or you feel like there's no point, but unfortunately you need to believe, because it all depends on you, the stakeholders of the CSOS. Like we've been saying, I know a lot of people have said in the chat, it's on us to inform them, to make them better. So yeah, sorry, I know I spoke a lot there.
I want to really add on to that, and I'm glad that you mentioned the fees things, because I was wondering whether I should mention it or not, because there's 140 people here that would stone me if I talk about money, but there's a couple of things that adds on to it. And I saw somebody just mentioned, not everyone can afford it, and it's quite easy. You should do, there should be an exemption process maybe where you can prove you can't afford it. I think that if you do the fees, then they should definitely do a cost order. Because you'll have two benefits. Firstly, people won't bring willy-nilly cases like they do at the moment. People will think twice. So that's going to free up their time, number one. Number two, yes, there's more income, but I don't think that is the problem necessarily. Like you said, they it often goes to adjudication. They say they don't have jurisdiction. If they do that at application phase, immediately they're saving up time. They've got more manpower to actually deal with the with the cases and the caseload, etc. And the other thing that I've always been saying is, if you bring in the fee, then they can outsource the mediation, to managing agents maybe, or to insurance brokers, depending on what it is. You can use that fee, you can pay them. You don't need to employ more full-time staff. But before we went into the cost thing, seeing as though we've been wrapped on the fingers by Zelinda about all the negativity, I wanted to add one positive thing that I can say, and that is that the matters are moving much quicker.
Yes, absolutely. This last month or so.
Yeah. I mean, some of these applications were made 2 weeks ago, and I've already received notice. So that is well done on their bit. Now we just need to fix the orders.
Yeah.
I wanted to find out, I've managed to get Willie online. He's going to join us now as well. Obviously, he's also been incredibly busy and influential in the whole CSOS process as well. Richard Brits is an academic colleague of ours. I know that he's online. I've popped him a direct message, but he hasn't come back to me yet. Richard, if you are hearing us and able, if you could perhaps, step in and give us some type of academic opinion in regard to the intention of the legislature rather versus what you've experienced on your side. So Richard is an academic as well as a practicing attorney, so he sees it on both sides, which a lot of us don't, and it would be quite nice to get his view. So Richard, if you are able to step in, please do. And then Willie, I know that you've just joined us as well. If you're able to give some of your opinion, we've had quite a heated engagement with Hendrik and Nicole thus far on a lot of the negatives about the community scheme ombud service and some of our positive potential recourses and solutions, including private mediation and petitioning the CSOS and reaching out to the minister and us as a community standing together and all those fun things. One thing that I know is not going to work, and this is going to sound negative now, so I must balance out my positivity, is that as a community, we're never going to stand together. Spending only 5 minutes on that Facebook group that I mentioned earlier will show that where we can fight, we will fight. Where we can fight each other and disagree with each other for whatever reason, we will do so. And unfortunately, until we can get over that mentality, we won't stand together. However, if we stop fighting, then we won't need the CSOS. So that's never going to happen. Yeah, very, very interesting way of thinking about it. Richard, you've you've commented there, not so much from your practical experience, but rather, being involved in academic writings on, how it's supposed to work in our property industry, if you've got any comments or takes there. Otherwise, ladies and gents, if you've got any comments or questions that you'd like to raise at this time verbally, you're more than welcome to. I know quite a few people have posted in the chat. Hendrik, is there anything that you'd like to raise under the chat, or anything you'd like to raise now?
Yeah, there's just two more things that I was thinking of. I can't remember when was the whole Indaba thing at Gallagher. You guys had the panel discussion with them, and I still held up a piece of paper to ask them about solar. And we went to them afterwards and we said, guys, you really need to give us guidance on how to deal with solar panels, because there's so many differing opinions and views, and there's no right and no wrong. And they said, no, they acknowledged they have to, and haven't heard anything from them. They're there to give guidance. And then the last thing I wanted to say was that I was contacted by a very dear friend of mine, who is a sociologist, and she deals with the mining and all those kind of things. And she was very much involved with the Marikana incident, etc. And they were having a career day at Marikana at the school, and it's it's really nice, bright kids, and but they've don't have a very big world. They don't necessarily know what is available as career options. And I asked the CSOS if they would mind having a little stand there, and I asked DTB and the PPRA, etc. And they were all very excited. Yes, it's their mandate to train specifically CSOS. And yeah, we never heard from them again. DTB was there. I believe it was a wonderful day, but that was also quite disappointing. So even that specific mandate, they don't take serious.
We've got Kerry Lee from NAMA that just joined us as well. So Kerry Lee, feel free to join us in the chat that we're having this morning about unfortunately our negative experiences with the community scheme ombud service for the last 7 years, and how we're identifying some positives, but not too many. Vili, I know that you're online as well. Please feel free to raise your comments. Ladies and gents, there's quite a lot of us this morning. I obviously need another cup of coffee. Any comments or queries or statements that you'd like to make? Vili, you're unmuted.
Yeah, so this morning I was having a chat, and I think it was with Colin, and I see that he's also on the group here, and it specifically pertains to a scheme where all the trustees at a moment in time decided to resign, and there was no trustees left, and then the managing agent proceeded to appoint, to call a special general meeting, and there was a quorum present, and new trustees were appointed. And then some of the people that were not happy with this went to CSOS, and they just gave an order, I think last week, that said that the meeting was not constituted properly because the managing agent had no right and authority to call the meeting. However, nobody could call the meeting because there were no trustees. So sometimes what we see from our side is that just common sense falls away, because who must now call this meeting? No trustees in place. Owners you can't get 25% of owners together to now state that to the trustees that they require a meeting to be called. And if the trustees don't call it, then they can call the meeting. So how do you now move forward? And surely CSOS, as the regulator, should understand these things, and they should give practical advice how to sort this out. However, in some other instances, we have seen some better rulings by CSOS. We recently had an AGM. I think Puna was of Meeting Pal was running the meeting for us, and the meeting was disrupted by a political party, and Then the meeting had to stand down. They chased everybody out of the physical meeting room. And then the meeting had to stand down because there was no longer a quorum present. So the meeting stood down to the next week, same time, same place. I then I sent a letter to CSOS, and I requested them that we can move the meeting to a different venue. And we asked that the meeting be moved to the police station in the area to ensure that the political party does not come and disrupt the meeting again. And CSOS actually sent a letter back to us, and they said they're happy that this can happen. It's in the same jurisdiction and it's very close. And they allowed the meeting then not to go to the same time, same place, but to a different place, but same time. And the meeting proceeded. Puna could run the meeting from the police station and the online portion thereof and so forth. So that was a very practical stance that they took in that regard to ensure that the scheme could actually fulfill its obligation to call a meeting, where on the other one, where we got the order last week, completely impractical. What do you do now? Now you have to bring an application to place the scheme under administration in terms of section 16. Once the scheme is under administration, the administrator can then call a meeting, and now the scheme can start functioning again, and then ask for his administration to be removed or whatever. I don't know. So sometimes weird orders that we have.
So if I can add on to that, I think that is why I really want them to start outsourcing some of the mediations and the adjudications to people in the industry, because I'm very passionate about, and I know it's caused massive fights, especially with my learned colleagues, that there is a definite practical side to the Act. And sometimes, there's a bit of a gray area, but it's a practical thing. And if you haven't practiced in the industry, if you're a full-time, you're an advocate, you haven't practiced in the industry, you're going to be a black and white kind of guy looking at the Act. You're going to miss that practical side completely. And that cuts out, there's so many disputes that can be resolved by just looking at it a little bit differently and not with necessarily a legal mind. And I think that is where this comes in as well.
Yeah. Carrie Lee, would you like to make any comments on behalf of NAMA in regard to what NAMA is doing with CSOS, the meetings that you're having, if you're able to comment? And then Jolene, if you'd like an opportunity to say anything, I don't want to put you on the spot at all, or even if you've got anything that you'd like to share with us from the PPRA's perspective.
Hi there, Linda, and everyone in the meeting. Thank you for having me. I'm sorry I had another meeting run over time, very over time. So I'm just catching the end bit. We do have a quarterly meeting with the CSOS. So these sorts of issues, okay, I don't know everything that was discussed now, but I have had some issues with enforcement orders that have been escalated to me, and then I obviously take it up with the CSOS. But we do meet formally on a quarterly basis with our board of directors. So anything that needs to be discussed, we can escalate it in that meeting. It's minuted, and there's action lists and all that accompany it. Otherwise, even in between that, if there's anything that you would like me to take up, I'm more than happy.
Fantastic, thank you. Carrie Lee, do you have to be a managing agent, and do you have to be a member of NAMA to engage with you on any points?
So that is preferably, I think that is the point of NAMA, is that we assist our members. But if there are burning issues, I do want to know about them.
Perfect. Would you just mind sharing your email address or the email address that people can contact you on in the chat for us?
Yes, I can do that.
Fantastic. Thank you so much. Thank you.
Thanks, Linda.
No problem. No problem. Jolene, anything from your side?
Yes, thanks. Thanks so much. It is disheartening to hear about my beloved CSOS that I've been there, for 8 years. Obviously we were there a year prior to inception. And it's one has challenges, and we must just make the best of it, and it affects us all because we're all property owners and we all live in a community scheme, and we all have clients to that effect or whatever. But from the PPRA side, I'm awfully excited what's going to happen. Like as Zerinda said, I am co-hosting the webinar for Zelinda and her team in December. We're going to talk all things PPRA. So many things that's happening here. If you are a managing agent, please, 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 I can't register you now. Your estate agency FFC is no good. I need to give you an exemption. So if you steal your client's money still, they can still come and claim against our fund. There's a Section 4 exemption. I know Kerry from NAMA did a bulk exemption for NAMA clients. If you're not a NAMA client, please, please, please email me. My email address in the chat at the PPRA. We need to get you that exemption. We're only going to register you from 15th of December. Thank you. Thank you very much, Zelinda.
Cool, 100%. So we're, at least myself and my partner, Nicole Tavares, are closing shop on the 15th of December. So we'll be sure to reach out to you before then, Jolene, for our webinar. Ladies and gents, we've got a couple of minutes left. If anybody would like to come online and raise any comments, you are welcome to do so now.
If I could maybe ask a question. Sorry, and I think it's for the members as well. I would really like to get some opinions on what the people think about the adjudication process at this stage, where it's not an in-person thing, it's done on documents. I would love to get some
Sorry, I don't know how to raise my hand. It's Linda Horsfield.
That's fine, Linda, over to you.
Okay. When people have finished answering Hendrik, I'd like to raise something, please.
Sure, 100%. I'll come back to you, no problem. Just a comment from my side on that, and I see that Derek has got his hand raised. When it comes to us receiving the request for final written submissions, we do suggest to whoever we're representing that they do ask for actual adjudication proceedings, either via Microsoft Teams, alternatively physically at the scheme if there's a need for that. Architectural guidelines not being adhered to, or a building issue or anything along those lines. The CSOS cannot decline that. The CSOS can, however, find that it is more suitable for the adjudication proceeding to be dealt with either at their offices or via Microsoft Teams, but they cannot force you to do final submissions. What the adjudicator can do is ask for final submissions either before or after the actual physical proceedings. So just keep that in mind. And a lot of people that we deal with are not writers. They're not able to put their point across in writing. They would much rather prefer to speak. And quite honestly, you very quickly get the gist of somebody's issue, and of course, just an understanding of who they are and how serious they are about resolution if you do actually engage with them, videos on and all that fun stuff, or physically. So that's my comment on that note. Derek, over to you. You're on mute.
I'm unmuting, start video. I don't know why it's not doing. Yeah, thanks, everybody. Thanks, Zelinda, Hendrik, and everybody on this meeting. So I did post a note in the chat box, and Zelinda, you're absolutely right. The challenge here is that even attorneys battle with court cases that were heard in sort of written submissions only, and then you have people that they have a fair argument, either as the applicant or both the respondent, but they just don't know what's important to put in the adjudication submission, in their submissions. What I find surprising, though, is, and I put that in my note, is that all adjudication sessions were undertaken, oath was taken on both parties. It's not even a requirement from CSOS that they should be made as an affidavit. So you're correct. In all my submissions, I make it an affidavit. And to answer your point, I've requested in every one of the cases that I dealt with, in-person hearing, obviously depending on where I felt that the facts that were put onto the table were not correct, and that the adjudicator may find that I find that it would be at risk on some written submissions. Not one has been entertained. So, yeah, not one. And I've got countless arguments or countless cases where that has been. There was not even a response. I mean, not even one of the things is that, that there should be a choice to actually choose an adjudicator. That process is not followed. Yeah, but more importantly, I want to get back to a point that I think the case officers should have more power as to whether a case should be entertained or not. Yeah. You can see quite clearly that there is no basis for a case. There's no merit. And CSOS should stop it, because it's just taking unnecessary resources where it gets referred to conciliation. Before it even gets to conciliation, there's not going to be a resolution at that meeting. And then it goes to adjudication. And you just hope in the outcome that the right award is made.
Unfortunate. Mr. Rampal Hirilal, you had your hand raised earlier, but I see that you've just disappeared away from your desk. So is there anybody else that would like to make any comments?
There is.
There we go. If you can just unmute, and I hope I pronounced your name even slightly correctly.
I'm not sure if he heard you.
Something wrong with form of Zoom that I'm on, and that's why it doesn't work. I have no opportunity to interact at all.
Oh,
So whatever this is,
we can hear you.
Use Zoom one.
Sarah? Sarah? Nope. Okay. Anyone else, ladies and gents? Kerry Lee, you've got your hand raised.
Yeah, sorry, I was struggling to find my hand there. So just on the paper submission, that was actually something specific that I took up with them quite recently. And they also did give the feedback that on the application form, a face-to-face can be requested. But I'm hearing now that that's not always entertained. So if I could have some examples like that as well, it's always nice to send them the examples. I also sent them some examples of where paper submissions were clear, there was clear facts and it was just kind of overlooked and the ruling went very wrong because of that. So yeah, if you could maybe send me a few. I think it was Derek. I think that would be quite ussul.
Perfect.
Something, sorry, Villy, my hand thing isn't working at the moment. I just want to say, Kerry, I always, when I request for clients the Microsoft Teams or face-to-face, I put it in the application, I put it in the response to the application, and I put it in the final written submissions. And I will be honest, I've never had an instance where they've refused a Microsoft Teams or a face-to-face adjudication on that basis. Oh, sorry. And when I send the email with the documents to them, I also say in the body of the email, please note that the applicant wants a Microsoft Teams or a face-to-face adjudication should it reach that point in the proceedings. So that's just something I do, yeah.
So note yourself, smoke signals, everything, just get it all up there. I'm going to take a comment from Villy and then from Linda, and then we'll call it a day.
So at the recent NAMA event in Durban, I had the discussion with Mervyn, the chief ombud for Natal, and he said to me that they are getting to the point where all the adjudications are going to be done in person again. So that is what he told me. I don't know if that is happening. We had a matter that was heard yesterday or the day before yesterday, and that was done via Teams. So at least it was not only a written submission matter that took place, but then, like Derek said, it was a matter that should not have even been heard because Confiance was appointed in terms of a court order in terms of Section 16 as the administrator, and they raised levies to a certain amount, which is their court-appointed mandate that they must follow. And some of the owners were not happy with the percentage, and they then took it to CSOS, and they sought fit to actually now entertain this, but we need to sort out the scheme within a 3-year period. So it's very difficult to sort out the scheme in that short period, and if you then hamstrung by CSOS that stops you, then it creates a problem. But where a court has ordered you to actually do it in that period. So sometimes they do look at stuff that they shouldn't actually look at.
Yep, definitely. Linda, you had your hand raised earlier and you said you wanted to raise something.
Yes, please. Thank you very much. I believe that the problem starts at the source. The problem starts with the legislation, both the STSMA and the CSOS Act. We were told when the new act came out that it was to make things easier. Well, it's made it substantially harder. As a chairman of multiple complexes over the years, I now find that my responsibilities have increased dramatically, but my authority has been reduced. 2 examples are, in the past, if your account was in arrears, you couldn't vote except for special resolutions, and you couldn't stand for election as a trustee. Well, now you can. We had a situation a short while ago, someone owns 300,000 Rand to the body corporate, and they were nominated as a trustee, and I had to allow it because in terms of the Act, it says anybody may serve as a trustee. Furthermore, it says you cannot be prevented from voting without an adjudication order. So it now means you have to go to CSOS or you have to go to court to get an adjudication order. We delayed the AGM by 4 months waiting for an adjudication order, ordering that this person could not serve as a trustee and vote. We never got it. So that used to be standard. If you were in breach of your conduct rules, you were ruled that you were not eligible to serve as a trustee. That's gone away. So the responsibilities have increased dramatically. The authority has reduced. And it does seem like the Act was written by attorneys to ensure a guaranteed stream of clients going forward, dealing with matters that in the past were the trustees could deal in terms of their authority without having to engage. Now, someone talked about Mervyn. I also discussed something with Mervyn at the NAM and Daba. The CSOS and Daba. And it was with regard to an order where the adjudicator stated that someone could pay off what was owed to the body corporate over a period of time. Now, in my opinion, the Act is very clear. The owners approve the levy amount, the trustees resolve to charge that levy amount, the owners are told this is the amount you have to pay and when you have to pay it, which is normally the 1st of every month. Therefore, contractually as well, in terms of the conduct rules, it says you will pay in full and on time every month. And so I'm saying that adjudication order is not compliant with the law, because I don't believe an adjudicator has the authority to disregard the law, disregard the conduct rules, and impose his own time frame for repayment. But that means that we would have to appeal it. And so it's easier just to say, you know, look, we know they're not going to pay, which they didn't, and accept it. But the fact that these orders are handed down that are clearly outside the authority of the adjudicators, and there's no recourse to be able to go to CSOS is to me is absolutely an injustice.
So Linda, just to add to your point, obviously when Linda and I were at the most recent NAMA event in KZN, we actually spoke to someone from CSOS about the whole internal review process, and they said to us, you know, before it was announced that they weren't going to be going ahead with it, that
it hasn't been officially
before it had been decided, he said that they were personally against it, because if you compare CSOS to the CCMA for labor disputes, if you go to arbitration at CCMA and you are upset with that arbitration order, the only further recourse you have is through the court, which I accept, but the CCMA unfortunately does operate a lot better than the CSOS. But then also, that being said, it has been around for a much longer time. So then the question is, do we need to give CSOS longer time, or but I completely feel your frustration. And it's like what Hendrik and I said now earlier is, what's the whole point of this amazing affordable / free dispute resolution process if at the end of the day you're going to have to spend over 50,000 Rand going to high courts, you know?
I think that they should copy the rental housing boards, where you do your objection, you have your adjudication, your tribunal, and that's, you know, I mean, that works so well. And I don't know why, because they're in the same industry, why they are talking about CCMA. I'll tell you why they're talking about CCMA, because all the original adjudicators were labor lawyers, and they were handing down, you have to issue letters of warning. You've got, and I'm going, what? I've been in HR for 35 years. I recognize it immediately. They were actually trying to comply with the Basic Conditions of Employment Act and not the Sectional Title Schemes Management Act or the CSOS Act. And that's the fundamental, is that the adjudicators, there should be adjudicators who are specialist, sectional title specialists. The other thing is the adjudicators are paid. So the incentive is, we'll take everything. And I've had situations where I've written back and said, why are you interfering? This is falls under the ambit of the Rental Housing Board, because it is actually a dispute laid by a tenant against an owner, because the body corporate issued a fine to the owner. And in that case, they actually did come back and accept that they did not have jurisdiction. But if I hadn't known that, they would have proceeded and it would have gone to adjudication, and some adjudicator would have been paid a fat whack to turn around and say, sorry, it's not our scope of authority. It's actually just a money-making scheme, in my opinion. From what my experience is, CSOS, it's just another jobs for pals, and you know, things that could easily be resolved are not, because somebody's getting paid to resolve something.
Linda, thank you so much for your comments, and we take your views on board most certainly, and your many, many years of experience in HR definitely makes sense. I said to Matthew next to me, that's exactly what we said yesterday. Thank you all for joining us. I really do, well, we all really appreciate it. Hendrik, thank you so much for the time in preparation. I know that you don't do anything without it being completely full mast, so thank you so much. For those of you that are not on that Sectional Title Living in South Africa Facebook group, please do join there. If you need any further information about our webinars going forward, our neighborhood, as Carl spoke about earlier, please do contact us. Don't forget to reach out to Kerry Lee at NAMO as well. If you would like to stay on for a couple of minutes, you are more than welcome to do so, but just formally for the record, we will say goodbye to those of you that aren't able to stay. Thank you again, and we'll see you next month in November for our penultimate webinar for the year. How scary is that? Thank you all.